Good evening and welcome to Slam the Gavel, the show that tells it all regarding family court, criminal court, and other court issues, as well as CPS. I am your host, Maryann Petri. You can find me, my books, and blogs on dismantlingfamilycourtcorruption.com, as well as on Amazon. My third book of Raised by These Wolves, Volume 3, has just come out, and it's also in audio as well. And I'm going to read to you an article written by my friend Justin Mcphail. He has written on Substack. Please follow him because he has a lot of excellent articles. And this one is titled Special Bulletin, Use Habeas Now to Test Unlawful Custody Orders. Okay. Now, this was written February 13th, the day before Valentine's Day. Okay. Now, the purpose of this is to inquire into the use of detention to determine whether the person under detention is being held under lawful authority. Ultimate purpose is to relieve a person from unlawful restraint, to give back to the person the legal custody of another. Okay. So now I'm not an attorney. I can't give legal advice because there's no such thing as good legal advice. Now, for those who have followed the Enforcement Not Reform series from the beginning, the premise has always been simple. Systems do not correct themselves through appeals to fairness. They correct when existing duties are enforced. We have argued that the problem in the family court is not lack of new rules, but failure to enforce the ones already written. Constitutional limits, statutory prerequisites, burden allocations, and adjudicative sequencing. This special edition does not depart from that premise. It sharpens it. If enforcement is the system, then the first question must always be whether lawful authority was properly invoked before coercive power was exercised. Jurisdiction is not reform. It is enforcement at the threshold. Justin Mcphail writes, Enforcement Series, the Special Bulletin. Before you spend another dollar in family court, okay? For years, we have examined enforcement as a structural core of family court power. We have asked who bears responsibility when the statutory and constitutional duties are not performed. This special edition refines that inquiry. Before pursuing appeal, modification, or reform, litigants should determine whether the court ever lawfully acquired authority to interfere in their case. Where jurisdictional prerequisites were absent and restraint remains ongoing, existing doctrine provides a mechanism for testing that authority. This is not a new theory. It is a disciplined return to the first principles. A necessary re-evaluation before you spend another dollar in family court. For years, we have described certain family court outcomes as corrupt, unjust, or structurally unsound. Many readers have focused on their energy on appeals, motions to modify, defense filings, public exposure, and reform efforts. Before you take another step in any direction, there is a question that must now be asked first. Did the court ever lawfully acquire authority to interfere in your case at all? This is not rhetoric. This is... Okay, the grounds. Number one, person continues to be unlawfully denied of one or more of their constitutional freedoms. Number two, there is a denial of due process. I'll add to that. Isn't there always? Number three, restraints are not merely involuntarily, but are unnecessary. Number four, a deprivation of freedom originally valid has later become arbitrary. Number five, court has no jurisdiction to impose the sentence. An excessive penalty has been imposed. Number seven, legal custody has been withheld. This matters now. Family courts unquestionably process general authority to hear custody disputes. That is not in question. But general authority over category of cases is not the same as lawful authority in a particular case. Courts do not acquire unlimited power merely because they are labeled chancery, juvenile, or family. Authority must be invoked properly. It must be supported by statutory prerequisites. It must satisfy constitutional minimums before the state may interfere with a fundamental parental right. If those conditions were never satisfied, then what follows may not be merely erroneous. It may be void. And that distinction changes everything. A properly invoked statutory cause of action, sworn jurisdictional facts sufficient to trigger the statute, proper service and notice, a genuine opportunity to present evidence, an adjudicative phase preceding any dispositional order, threshold findings supported by record evidence, proper allocation of the burden of proof. If these are absent, the proceeding may lack constitutional sufficiency to support judicial fact-finding at all. This is not a claim of unfairness, it is a claim of authority. Now, Justin continues, void versus voidable, the critical distinction. Many litigants confuse reversible error with jurisdictional defect. Not all processes failures renders an order void. Some are appealable, some are discretionary, some are simply adverse findings. But certain failures are different. Orders may be void where no statutory basis was properly invoked, no sworn jurisdictional facts were presented, no service of processes occurred, mandatory statutory prerequisites were ignored. Disposition preceded adjudication. The court acted beyond the authority granted by statute. Coercive enforcement, such as incarceration, occurred without required findings. Void orders are not insulated by time. Void orders are not validated by silence. Void orders may be subject to collateral attack. This is not an invitation to chaos. It is an invitation to clarity. On to Rule 102, Section 1. To what habeas corpus extends, except as otherwise expressly provided by law, the writ of habeas corpus shall extend to all cases of illegal confinement or detention by which any person is deprived of his liberty or by which the rightful custody of any person is withheld from the person entitled thereto. Where this matters the most, this analysis becomes especially urgent in cases involving ongoing restraint. Civil contempt, incarceration without ability to pay findings, child removal without sworn emergency basis, failure to conduct prompt adjudicatory hearings, enforcement of orders entered without service, continued restraint after the statutory purpose has expired. In such cases, the question is not whether the judge's discretion was properly exercised. The question is, by what lawful authority does the state continue to restrain liberty? That question is ancient. It predates family court, and it has a name, habeas corpus. This is not a universal filing strategy, let us all be clear. Not every adverse custody ruling is void. Not every thin layering is jurisdictionally defective. Not every unfair outcome supports collateral attack. This is not a call for reckless petitions. It is a call for disciplined evaluation. Before filing another appeal, before filing another motion to modify, before investing further time and resources, audit your own case. Was jurisdiction properly invoked? Were statutory prerequisites satisfied? Was adjudication completed before disposition? Were mandatory findings made? Is restraint ongoing? If the answer to these questions reveals structural defect, then the strategy may change. If not, then the traditional path may still apply. Why resistance is certain. Whenever jurisdiction is questioned, resistance follows. Institutions protect stability. Courts protect finality. Systems protect classification. Some will say the court has general jurisdiction. Any defect was merely procedural. Appeal was the remedy. Habeas is not a substitute for appeal. Those arguments must be anticipated calmly and addressed precisely. The strength of this approach will not be measured by noise. It will be measured by how carefully authority must be defended once questioned. Restraint must be actual and effective, not necessarily physical restraint. By any restraint which would prejudice freedom of action is sufficient. Shall not issue if the restraint is voluntary, except for a minor. Prepare, do not react. We are not calling for emotional escalation. We are calling for intellectual preparation. If jurisdictional defects are widespread in certain categories of cases, then exposing that fact requires careful record review, statutory analysis, constitutional grounding, narrow, precise argumentation, strategic selection of cases. If we are wrong, careful analysis will reveal it. If we are correct, the burden of justification shifts. Either outcome advances clarity. The final word. Whether one agrees with this framework or not, one reality is certain. The most powerful question in any legal system is not whether an outcome feels unjust. It is whether the state possessed lawful authority to act. Before you take your next step in family court, ensure that authority was ever properly established. Everything else follows from that jurisdiction audit checklist. Before you file another motion, ask yourself 3 questions. If your case generally raised alarms under any of the principles discussed in the 12 articles previously published on Justin Mcphail's website on Substack, it may warrant closer review under a jurisdiction first lens. This does not mean every case qualifies. It means some may. Now, begin with the following audit. Statutory invocation. What statute was invoked to justify interference? Was the petition properly verified under oath? Did the petition allege specific jurisdictional facts required by statute? Are those facts supported by sworn evidence in the record? If the statute requires particular threshold findings and they're absent, this matters, okay? Number 2, service and notice. Were you properly served? Did you receive meaningful notice of the allegations? Was sufficient time provided for you to prepare? Without proper service, jurisdiction does not attach. Number 3, adjudication before disposition. Was there a genuine adjudicative phase before any custody change or dispositional order? Were you allowed to present evidence? Were witnesses sworn? Was burden of proof properly allocated? Did the court make threshold findings before moving to disposition? Disposition cannot precede adjudication or mandatory findings. Did the court enter the findings the statute requires? Were those findings supported by evidence in the record? Were emergency findings actually supported by sworn facts? If a statute says the court shall make certain findings, absence of those findings may not be trivial. 5, coercive enforcement. Everybody listen up on this one. Was incarceration ordered? Was an ability to pay finding made? If financial contempt? Was there a clear purge condition? Is the restraint still ongoing? Has the statutory purpose expired, but enforcement continues? Where liberty is physically restrained, scrutiny intensifies. Number 6, structural irregularities. Were psychological evaluations ordered before adjudication? Were burdens inverted? Were you denied opportunity to challenge jurisdiction? Was access to appeal obstructed during restraint? Did disposition effectively occur without proof of liability? If multiple red flags appear, your case may require deeper jurisdictional review. Okay, when habeas may become relevant. Habeas corpus is not a substitute for appeal. It is a remedy for unlawful restraint. It becomes relevant where the underlying order is void, not merely flawed, jurisdictional prerequisites were never satisfied, liberty or custody remains restrained, no adequate remedy exists through ordinary appeal. If your case aligns with the structural concerns outlined across the previous 12 articles, particularly where adjudication appears to have been bypassed, careful evaluation is warranted. Detailed instruction on posture and drafting will follow in future publications. So Justin continues to write, State versus Federal Habeas, which is a general overview. There are two broad avenues. Okay, state habeas, filed in state court, typically where the restraint occurs, used to challenge unlawful incarceration, certain custody restraints, void judgment. State habeas often focuses on jurisdiction and present restraint. Federal habeas, filed in federal district court after the state remedies are exhausted. Federal habeas is narrower and often limited to constitutional violation, custody as defined under federal law. It is procedural, complex, and not a first step in the most family court matters. More detailed guidance on procedural posture will be provided soon. But now, understand this. Habeas is powerful, but only when properly positioned. Now, Justin continues, expect resistance. When jurisdiction is questioned, resistance follows. Likely arguments you may encounter. The court has general jurisdiction over custody matters. Any defect was merely procedural. You should have appealed. Habeas is not substitute for appeal. Family court is civil, criminal standards don't apply. Best interest findings are discretionary. This is settled law. You are misusing habeas. You are attempting to relitigate the facts. And I've heard that one. I'll add to that. I've heard that multiple times out of the family court judge and the child support judge. It's unbelievable. This theory has already been rejected. Some resistance may be quiet at first. Institutions do not immediately respond to ideas they believe will fail on their own. If the idea begins to gain traction, responses may intensify. The soundness of strategy is often revealed not by applause, but by the effort required to suppress it. Remain calm, remain precise, remain disciplined. Now, moving forward, for now, the goal is awareness. Before spending additional resources, conduct the jurisdiction audit. Review the record carefully. Identify whether your concerns fall into void or voidable territory. If you believe your case may qualify under the jurisdictional framework described, you can email Justin McPhail at .net, JustinMcPhail at att.net. Indicate jurisdiction audit in the subject line. Justin is committed to seeing this through. That may include future written guidance, video explanation, or structured case-by-case discussion if warranted. And for now, preparation is the priority. Clarity precedes action, and more instruction will follow shortly. And I totally appreciate Justin Mcphail for writing that. And he wanted me to add this as well. That has come about all because of the family courts. Habeas petitions traditionally applied in cases where the child was held in state custody. That time, then you were class of case that we deal with now between two parents was not a problem. The theory is that these newer cases, because they are so egregious and because they are performed in the absence of essentially any judicial requisites, they qualify for hideous relief, just as old cases did. The entire process is designed to effect one hearing very quickly to review evidence used to justify the violation of fundamental rights against the parent, meaning that whatever evidence the family court used to remove the child from your home or to alter, the custody has to be reviewed by a different court in different with a different judge and the one who performed the unlawful removal. That means another judge and another courtroom with no prior knowledge of the case will be compelled, rule properly based on the lack of evidence, or rule improperly, thereby involving himself substantially in aiding a conspiracy to violate fundamental rights. Essentially over that, Justin encourages others. This has potential to undo years of harmful litigation in a single hearing, and most, if not all, of the cases we discuss should qualify. And I totally appreciate Justin Mcphail. He's been on my podcast a couple other times. He's the gentleman with the map behind him. Okay. So thank you all for joining me and listening to this. Slam the Gavel is a podcast to help the public understand what really goes on in these courtrooms. I'm your host, Maryann Petri. You can find me on Spotify, YouTube. Please like and subscribe. Apple, iTunes, iHeartRadio, Google, and other platforms, as well as dismantlingfamilycourtcorruption.com. Again, feel free to buy me a coffee to help keep this podcast going. Thank you, everyone, and have a great day.